Good morning, Your Honors. May it please the court, my name is Amy Dovey. I'm from McCumber Daniels and I represent the appellate, Brookdale Senior Living. I'd like to reserve 5 minutes for rebuttal if I could, Judge Morris.
Yes, ma'am.
Thank you. The trial court erred in denying Brookdale's motion to compel arbitration when the exact same slip and fall claim against the condominium association is being arbitrated. The claims arise from the same allegations. They're based on the same operative facts. They are inextricably intertwined and they fall directly within the scope of the arbitration agreement.
Well, how can you prove that your client Brookdale was identified in any of these documents, including the arbitration agreement, that the arbitration agreement is broad enough to include alleged successor in interests and assigns, when, first of all, I don't know if you argued this below or not, but your colleague conceded that it was a complex corporate structure, but never articulated what the structure is. The bottom line is they're a non-signatory, correct?
Oh, correct, Your Honor.
So it just seems as if you're just saying it's not fair that the nursing home gets to arbitrate, but we got to go to trial.
Well, Your Honor, again, as you mentioned, the arbitration contract is very broad in scope. It is not limited to just the parties of the agreement. It's limited to.
Why isn't it? Because it says disputes between you and us, not anybody else. I've seen other cases. I did research. There are arbitration agreements that include heirs, successor in interest, assigns, everybody on the face of the earth. This does not. It says between you and us. And then it talks about services by us. And then it binds only Ms. LaCastro's heirs and relatives. And then it talks about either you or we may initiate arbitration. And it's only signed by Ms. LaCastro and a representative of LSS. So unless you're some type of third-party beneficiary, and I just don't see that either, because Ms. LaCastro did not contract with your client in any shape, way, or form. She was not aware of it, not ever made aware of it. How can you bind her when you're not even a signatory?
Your Honor, the arbitration agreement encompasses all of the services provided to Ms. LaCastro while she is in residence at the independent living facility. It was signed on the same day and in conjunction with the membership agreement. And at that time, there was a different management company that signed the membership agreement, but the membership agreement specifically talks or addresses that one of the services provided will be the maintenance of the common areas in the condominium building. And it also addresses that it applies to any successors to the management company that signed the agreement. So that assignment makes Brookdale a part of that agreement. The membership agreement.
But you couldn't prove that they were successor in interest below. When the judge asked, what's the connection? What is the business relationship? It was crickets. There was no argument. You didn't know the corporate structure. You could not explain it. You simply argued it wasn't fair.
Your Honor, there was no dispute whatsoever that Brookdale was the one providing those services. And
that doesn't matter. What is the corporate relationship? It doesn't even identify Brookdale as an assign or an assignee.
In the Chroma makeup case in the 11th Circuit, it addresses the issue of whether non-parties to an arbitration agreement may enforce the agreement. And the 11th Circuit, relying on Florida law for the equitable estoppel doctrine, specifically discusses whether or not someone could enforce the agreement. In that case, it was a trademark infringement case. The contract was actually a distribution contract. And 3 parties were sued, the Kardashians, their makeup company or whoever they hired to create a makeup, and then this this distributor was sued for not paying settlement funds to the Chroma Makeup Company in the first place. The only party with the contract was the distributor, and it was a contract for distribution. It didn't have anything to do with the trademark infringement claim. The courts in that case found that the dispute could not be enforced. The Kardashians couldn't enforce it because it was limited only to the disputes between the parties. And Your Honor, we disagree that the arbitration in this case is limited to those disputes because it is such a broad language.
But where is it broad, talking about servicers, maintenance companies, or anything in this arbitration agreement? Because we're all familiar with the law about nursing homes and agents of the residents binding the resident to an arbitration agreement. But we have law out of this district, the Olson case, the Henderson case, that a non-signatory who seeks to invoke arbitration is only allowed to force them to arbitration if they fall within the identified class of persons expressly intended to benefit from the arbitration agreement. I'm looking at the arbitration agreement. I'm not looking at the membership agreement, but the membership agreement makes no mention whatsoever that Ms. LoCastro is binding herself to any other entity.
Again, Your Honor, of course, the membership agreement is important because it does incorporate and it contemplates successor entities.
So what record evidence is there that Brookdale is a successor in interest of LSS? Where is it? The judge asked for it and you didn't have it.
We do not have that contract, but
Thank you.
But Ms. LoCastro herself absolutely agrees that Brookdale was providing those services. There is no dispute whatsoever that Brookdale.
Well, that's because her attorney has to exercise due diligence. Otherwise, he's probably going to blow the statute of limitations for not suing the right parties. That happens all the time. The fact that he sued Brookdale does not mean that Brookdale's entitled to arbitration.
Your Honor, the fact that he sued Brookdale for carrying out a non-delegable duty that was owed by the condominium association, who was mentioned in the membership agreement, brings that within the same operative facts. It's an inherently inseparable claim. Whether or not the condominium association is going to be held liable depends expressly on the facts of whether or not Brookdale was negligent. So you cannot separate the claims. The exact same claims need to be determined in both settings, and this is the exact situation in which equitable estoppel allows a non-signatory to enforce an arbitration agreement. It's not just because the claim arises from a contract, although that's one situation in which equitable estoppel applies, but it also applies where there's concerted conduct or there's inherently inseparable conduct. And for instance, in the third DCA in Kolsky, it dealt with 3 different groups of defendants. So let's just kind of break this apart a little bit. The Kolsky court looked at the defendants, first of all, that was an individual defendant. The claim against her directly arose out of the contract that she was assigned to. So even though she wasn't a part of the arbitration agreement, she was a non-signatory, that the first type of equitable estoppel applied to her, and the court found that she could enforce it. The second group of defendants were 2 corporate defendants that were members of the corporation that had signed the arbitration agreement. Because they were members of that agreement, the third DCA allowed that group of defendants to enforce the arbitration agreement. And then there is this third set of defendants. The court doesn't really even describe who they are in Kolsky. It just refers to them as quote unquote the other defendants. These other defendants were allowed to enforce the arbitration agreement, even though they were non-signatories, even though they were not signed in, not mentioned in the contract that we know of at all, merely because the claims against them were interrelated with the individual defendant, and so the court found that equitable estoppel applies. And that's why equitable estoppel will apply in this case. These claims are exactly the same. I mean, practically word for word in the complaint against the condominium association, which it would be like the individual defendant in Kolsky. And because then the plaintiff brought the exact same claims against the Brookdale, who was, again, I can't emphasize enough, was actually fulfilling the non-delegable duty of the condominium association. So they even to the extent that they were not a party to the contract, were not mentioned in the membership agreement at all, they assumed the obligation of fulfilling the condominium association's role under these contracts, under these group of contracts. And by fulfilling that, taking on that obligation on themselves, then they are.
Ms. Dilday, is there any evidence to suggest that Ms. LaCastro knew that they were performing these functions?
Yes.
Tell me about that.
I don't actually know if there's documentary evidence in the record. I don't think there is, but in the
I'm asking from an obvious apparent authority type standpoint.
Sure, Your Honor. In the hearing, Ms. LaCastro's attorney said, I don't care what Brookdale was doing. We don't have an agreement with them, but they were providing services. And then he went on to say, their name is on across the top of every single document that we have. I honestly, Your Honor, I would have to go back and look through the hearing to find that page number. But
the concept here is if they were taking care of these common areas, and Ms. LaCastro knew they were,
right,
then they were cloaked with apparent authority from the signatory to the agreement,
right,
to do this, and that might change what you're dealing with here. And I don't want Mr. Levine to think he's going to have a cakewalk. I want him to understand he's got an issue too. So that's why I'm asking this question, because most of what Judge Sleet asked you were questions I had as well, because it is a concern that that your client was not a signatory, and there's nothing in these agreements that would suggest that they step into the shoes of a signatory. So I'm looking for outside the agreement arguments, and this would be one that I would be interested in, but you don't really have anything for me.
Again, maybe by rebuttal, I will find that page number in the transcript.
Okay.
Yes,
Thank you.
That's what I have. She was aware that Brookdale provided the services, and her attorney conceded over and over. In fact, in their answer brief, they said Brookdale was the one providing these services. So that there is that authority. Yes.
Okay. Thank you.
So we believe that equitable estoppel would permit Brookdale, because again, the scope of the agreement was for the services relating in any manner to the treatment of services. The claims track word for word, and the membership of agreement applied to the successor companies. Brookdale took on that responsibility. They were doing the operative work for the condominium, and it was a non-delegable duty. Therefore, whatever liability the condominium might have in the arbitration is going to hinge directly on whatever Brookdale did, right or wrong, as far as maintaining those arguments. Unless the court has other questions, I'll put my mind to looking for that bit of evidence, and like to reserve my 5 minutes. Thank you, Your Honor.
Thank you. You have 5 when we get back.
All
Mr.
right.
Levine?
Good afternoon, Your Honors. This is Roger Levine on behalf of the appellee plaintiff, Ms. Mildred LaCastro. I wanted to first correct a few things where opposing counsel is describing about the awareness of or provision of services for. We only know that Brookdale happens to be there at the condo building, at the condo association. We're not really sure what exactly the relationship is. I just did a quick recheck.
Well, as you've heard, from my questions, Ms. Dilday, I'm very interested in the estoppel and apparent agency arguments, because the documents themselves, I think, are pretty clear. So, my question is, was Brookdale held out as, an agent of the signatory? And if that was, and was there evidence about Ms. LaCastro knowing that? In other words, that they'd be a stop to deny that that Brookdale was doing their work for them, and they would have cloaked Brookdale with a parent agency, and that people came to rely on. So talk to me about that.
Well, if there was any proof of agency before the trial court, or even in the appendix, which constitutes the record that was prepared by the appellant, then surely they would have used the word agent within the statement of the case and facts in their initial brief, or after we pointed out in the answer brief that there was no use in their statement of the case and facts, in their reply brief, they'd have done a renewed statement of the case and facts that would have shown where an agency relationship existed, but no proof was presented, no proof was given. It's the same thing where you're talking about either a successor or a parent, no information was given. I know that argument of counsel doesn't constitute evidence, which is something that it appears in going through where they're saying that we are acknowledging a relationship. They're probably referring to page 74 of the transcript, but that was trial counsel saying that he doesn't really know what the relationship is, was just kind of guessing that there might be a parent that is independently providing, because trial counsel could not and even show any proof of, let alone through admitting an argument, that nothing was available yet. So it's very premature. When you look at who the contract is actually signed by, it's with American Retirement Corporation, which then doesn't really appear anywhere else. In the joint motion to dismiss and move to arbitration that was filed by both Brookdale and the Condo Association, they had the opportunity to draw a relationship, but did not do so. It's just kind of hanging there, and there is no connecting of the dots. There is no corporate family tree. So we have no real idea about any of this. In moving to address the common issues of fact claims raised in the beginning of oral argument, that's also highly distinguishable. I mean, yes, there was a slip and fall. Yes, we're presuming that in some way Brookdale is involved, but we don't yet know if there's going to remain a permanent overlap or to what extent there's an overlap in the claims between those against Brookdale and those against the Condo Association. Since everything to move to arbitration was done at an incredibly early stage of the proceedings, there's been no real discovery that could further differentiate the full extent of the duties and liabilities by an actual signatory versus, or a potential signatory to an agreement that Mrs. LoCastro hasn't even taken a position on yet, versus a total non-signatory. When opposing counsel is describing arising out of the same common facts, that it's anything arising out of, super broad, anything arising out of, that's really forcing arising out of to do incredibly heavy work that even the Florida Supreme Court wasn't willing to extend to. In opposing counsel's reply brief, they rely on the Supreme Court case of Sefrit. I may be mispronouncing that, but 757 Southern 2nd 633, and that was a case where you had a home buyer bought from the home builder and then died due to carbon monoxide poisoning that was being released from the garage and carried into the house. And that was considered outside of arising out of. In the same situation that opposing counsel wants arising out of to be as if it's anybody that might be, any entity that might be tangentially involved, whether it would be the architect or the flooring buyer or the flooring installer or the flooring who supply the manufacturer of the flooring materials. But that's well beyond the scope of arising out of for the relationship of being at the facility. And Sefrit would say, no, that doesn't apply. in going through, opposing counsel brought up one of the cases that was addressed, Chroma, which was raised in the answer brief. But that was again to show where there is no proper relationship between the parties. You don't get to, the non-signatory doesn't get to just slide or wiggle in. It's only with an agreement that once it's established between the signatories, they can get in if there's some rare exception. 3 of the cases that are relied on, Ocwen, Tennant, and Cocelli, those are all cases that the 3rd district decided would be very rare exceptions, because you should not be able to easily join an arbitration if you didn't agree to it. Otherwise, people should reserve their right and, maintain their right to sue in the court of their choice. And Mrs. Locastro is choosing to sue in the trial court. As far as the arbitration agreement itself, the objection was at the time, there was the joint motion to dismiss and move to arbitration. The objection was only raised initially to Brookdale as far as it relates to the condo association. At that early stage, Mrs. Locastro wasn't yet taking any position, and that was even renewed, so that you can see on page 50 of the appendix, as well as you can see that being renewed on page 69 of the appendix at the hearing transcript, where trial counsel is indicating that a position wasn't being taken yet as far as whether or not to fight the arbitration contract in relation to the condo association. So they're trying to move, Brookdale's trying to move into a process which hasn't even been initiated yet, because there hasn't even been a move into arbitration with the potential, with the listed signatories to an agreement that hasn't been fully disposed of yet. And was separately a distinguishing factor in one of the cases raised by the appellant, where a reason to move into arbitration was because there was an already ongoing one, where you had such a vital, indispensable party, and arbitration was already ongoing. We're not at that stage yet. They've moved prematurely, and they haven't produced any of the material that they needed. I feel that I'm fully addressing the current questions by the court. Is there anything further that your honors would prefer to ask?
I think you've covered it.
Okay, I just don't want to keep beating a dead horse here with these cases.
And we appreciate that.
So I prefer to rest on the brief and the lack of material that would support in the appendix or in the appellant's 2 briefs, and respectfully request that this court affirm the denial of Brookdale's ask to arbitrate.
Okay, thank you, sir. Ms. Dilday, you have 5 minutes.
Thank you, Your Honor. Well, I did look through that transcript, and we've got on pages 70 and 74, it is counsel saying Brookdale was providing those services. As far as evidence as to a reliance by Ms. Locastro, other than counsel's representations, there's not evidence, quite candidly, to let you know that.
Okay,
I would like to just comment on the parent company issue. It was brought up at the hearing. It was not me. The trial counsel did discuss the corporate structure, of which Brookdale Senior Living is the highest member, and all the other corporations are subsidiaries to Brookdale. And so she did argue, as an aside, that the parent company can enforce this agreement. Counsel did not actively dispute that characterization of the company. It was not disputed. They just said, well, even if it's the parent company, it's providing services directly. It's not providing services through its subsidiary, and so that makes a difference. But we know that this case law discussing estoppel, especially Kolsky and some of these other cases, disagree with that a parent company, indeed it allows it. The reason equitable estoppel is there is because it prevents a plaintiff with an agreement with a subsidiary to go to the parent and sue and avoid the arbitration agreement. So that's why equitable estoppel is there in the first place. And that's to extent what has happened. I just really briefly want to discuss, as you know, Your Honors, a motion to compel arbitration has to be the first thing that we file out of the gate. There can't be discovery. There can't be a, oh, let's find out what really happened between who did what, da, da, da. So, so that's why Kolsky said you have to rely on the allegations of the complaint for this analysis. You can't go into discovery. That's just a basic arbitration law, as is the fact that if plaintiff wants to insinuate that they're going to, in the future, argue that the condo association also isn't entitled to arbitration, I think that that bird has flown the coop. And the reason I say that is that in Angel Senior Living, this court has said that you cannot come back multiple times for multiple motions to compel arbitration. And just as an equitable point, I would like to say that if that's true for the defendant, I would think that when we raised it in our first motion, that should also be true for the plaintiff. So for those reasons, I think that that's not a point. The same claim, the same allegations are all relying on what Brookdale did as performing under the contract are going to arbitration. And for that reason, Brookdale should also be entitled to arbitration. Again, I'd respectfully request that you reverse the order to as it applies to Brookdale and allow Brookdale to compel arbitration. Thank you.
Thank you both very much. I appreciate your hard work and arguments in this case.